Yeah, and so here's sort of the questions. Can you explain this law that passed through the Senate? And is it red flag law? Is it Marsy's law? And how are you voting on Marsy's law? And according to your understanding, are there any gun control red flag provisions in this law? And please explain why you voted for or against the Marsy's law. And so there you go.
I will start because this is going to be a long conversation. I voted in favor of Marsy's law, and what that does is it puts it on the ballot for all of you to have your vote. And when I go to the ballot box in November, my vote will be equal to yours. So let me tell you why I supported this as a constitutional amendment to put it on the ballot. Right now, in 1990s, maybe 94, I think, Idaho became one of the leaders in victims' rights by putting some protections in the Constitution to offset the protections of the accused. And the protections of the accused have increased, but the protections of the victims have not. So think about the fact that in the whole scheme of a crime, the victim is the only one that didn't choose to be there. And they need to have some protections put in place. Some of my legal friends here reminded me that they aren't really rights, they're protections. So I'm going to change to the correct term. They're protections. The question in the Senate and why a few people didn't vote for it is because they felt that putting those increased or updated protections in statute was just fine, and that we didn't need to send it to the people for a vote as a constitutional amendment upgrade to what's already there. But I think the people should have a voice in it, and so I voted to pass this on to the ballot box so that everyone can have a choice. I will tell you, there's not a person that I've talked to in the legislature that believes there are any red flag indications or connections at all to this. And I do not understand why some outside parties are trying to gin up a fear tactic to say that the government's coming to take your guns, because it's not true. It is absolutely not in this. The Second Amendment overrides everything. That's our US Constitution. And even the Idaho Constitution, our state constitution, Article 1, Section 11, has even more clearly stated protections for anyone's right to own a gun. And the only way that it can be confiscated is if you're convicted of a felony. So that is it. And there are no ways that this law is a red flag and can cause gun confiscation. So please, just don't, you have to look into these things and not just believe some of the fundraising efforts by some outside groups. But we have studied Marsy's law in the legislature for a couple of years. Experts in constitutional law have come. We have tons of lawyers in the legislature, and no one thinks that there's any implication for gun rights. I also think that we really need to focus on the rights of the victims, the protections for the victims, and this law really goes a long way to help. So it will be your choice at the ballot box. If this goes through the House, then it will go to the ballot in November, and you'll all get a choice.
I don't know if I can add anything to that, but if you got a pencil and paper, a couple things you might want to review of the Constitution of the State of Idaho. Article 1, Section 1, the Declaration of Rights, and Senator Souza said it in a nutshell. The last sentence in that, it's only a couple of paragraphs, but nor shall any law permit the confiscation of firearms except those actually used in the commission of a felony. So she talked about stuff you see in the internet and media and stuff. Check it and to see if on those advertisements there's a donate button, because if there is, there's people making money off this. And the rumors, I was telling some of the folks before, I got a call the other day And somebody was actually concerned about registering as a Republican because Republicans carry guns. Hence, they're gonna come after our guns, the Nazi police. So I mean, it's nuts, all this stuff. So, I'm sorry, did I say that?
No,
Okay.
I'm just.
Okay. Another one to write down if you want to research this on your own. I ask everybody too, don't believe us, do your own due diligence. Article 1 of the Idaho Constitution, Section 22, Rights of Crime Victims. What this Marsy's law does is enhance those. There's some things that need enhancing to give victims, you know, the same rights as defendants. I started my law enforcement career in the early 70s. I know I don't look that old. But looking back, I worked Part 1 crimes, murder, robbery, rape, aggravated assault, sex crimes, juvenile crimes. And since this weird discussion came up last year, I was thinking, who are victims mostly? You know, it's your loved ones sitting next to you. The elderly, the children, the poor. I wasn't looking at you when I said elderly, I'm sorry. The young, the homeless, the poor. And so, ever since what Miranda versus, what was it, Arizona, Vito, in the early 70s or something, there's been a lot of talk about rights of the accused. And everything John Green said, I agree with, you know, about beyond a reasonable doubt. But ever so often, you gotta start thinking about, hey, let's talk about victims. You know, another thing that turned me on this was the ACLU's comments about this. And I took a lot of opposition because they were against this bill. And so I won't go into it, but if people want to stay after and discuss this in more detail, I'd be glad to. Thank you.
Well, that's going to turn into a little bit of point counterpoint here. And I need to tell you that Senator Souza and Senator Cheatham are two of the finest senators in the Idaho Senate. But we disagree on this issue, and fairly strongly, I might add. I want to read some things. So this is from Article 1, Section 22 of the Constitution. This is an existing constitutional provision. Because what I heard, and I was present at the committee hearings and the debate on the floor, and in this case, subject to some fairly intense lobbying in favor of this provision. So I believe I've heard most of the arguments, and most of the arguments centered around the right to have standing for the victim and the right to be notified for different issues. And the current statute says that a crime victim, as defined by statute, has the following rights, and I'm not going to read all of them, but it says, to prior notification of trial court, appellate, and parole proceedings, and upon request, to information about the sentence, incarceration, and release of the defendant. That's one of them. They have a right to be present at all criminal justice proceedings. They have a right to communicate with the prosecution. They have a right to be heard upon request at all criminal justice proceedings. They have a right to restitution. They have a right to refuse an interview, the right to read pre-sentence reports, the right to the same rights in juvenile proceedings. So the things that were talked to me about, that why we needed to amend our Constitution, it just appears to me that they have the ability to do that. And one of the things that really concerned me was that, let's see if I can find it here. I didn't bring my notes, but I'll just go to, I can't find the wording here. But the very last sentence of this law, this constitutional provision, says, this section shall be self-enacting. The legislature shall have the power to enact laws to define, implement, preserve, and expand the rights guaranteed to victims in the provisions of this section. So I don't take amending the Constitution lightly. We have a crime victims provision. And the example I used in committee was, we have, and we just talked about, Article 1, Section 11 of our Constitution talks about your right to keep and bear arms. We do not go in and amend that right when we think something has not been defined properly. I have been part of laws to expand concealed carry to all Idaho citizens in cities, out of cities. I have been part of laws that required universities to allow concealed carry on their campus. I have worked, last year I worked on laws to expand and better define our castle doctrine and our stand your ground laws. I have worked on laws on all of these issues. We have never gone in to amend the Constitution. The Constitution gives a right to crime victims, and I believe that right is well enough defined that we can make the rest of these changes by statute. The notification provisions, I believe, are not being upheld because we're not funding it properly, but they clearly have the right already. And I can't find it, but one of the changes, the other changes that concern me is we did change the definition of when the victim can be involved from when it's a defendant to just when they're accused. And that also is concerning of me. And so I just wanted to give you another perspective and why I voted against this provision when I had that opportunity.
We haven't had this legislation or proposed legislation in the House yet, but it's coming soon, I think. And first of all, I want to echo Senator Vick's sentiments about Senator Souza and Senator Cheatham, especially Senator Cheatham, because from life experience, there's probably not anybody in either house of the legislature that I have more common life experiences than Senator Cheatham, just because of what he did for his entire career and what I did for a large part of mine. So we start with the notion that all power resides in the people, and it's unlimited, and we can grant to the government those things that we think they should have power to do. The powers of the government are few and defined. They're very easy to find in the government. We haven't given them that power, they don't have it. Unfortunately, the government doesn't live by that rule, because 43 years ago, we had a group of unelected judges pass a law that says that they found in the Constitution, in words that weren't there, the authority to murder preborn human beings. And so, with all due respect to my colleagues who don't think it's an issue, and I'm not criticizing them, I understand their concern and why they think this may not be an issue, but the courts will find what they want to find in any law when it's ambiguous, and Marsy's law, if nothing else, is ambiguous in so many ways. The Constitution gives everybody the same rights. Crime victims have the same rights, but we can't say because you're accused that the person you're accused of making a victim has greater rights than you do, because you're innocent until proven guilty. And so if we take away, again, that presumption is so important. If we take that away and we give the victims more rights than the accused, then our entire judicial system is headed for catastrophe. We're not already there.
Would that be a good segue into the red flag laws?
Yes, that's where I was going.
Okay, good.
So the concern about these does anybody here not know what red flag laws refer to? Okay, so basically the red flag laws are when some law enforcement will say this person may commit a crime or may victimize somebody, and so therefore we have to go in and take some right away from them, particularly with regard to the possession of firearms. This happens sometimes in family violence or domestic disturbances. Somebody's accused of domestic disturbance. There is a short period. I'm not going to debate the merits of that right now because there's a lot still at issue there, but their rights to possess a firearm are taken away immediately, but they're also afforded due process in a pretty short order to determine whether or not that deprivation of rights is warranted. And so with red flag laws, the fear is that some judge is going to read into a statute, particularly with some of the vagaries of Marsy's law and what that would entail, and say, well, we're going to have a pre-crime decision that some person may be victimized, and because they have greater victim rights, we're going to go take away the Second Amendment rights of the person who may commit that crime without due process. And I think that's a really bad way to handle our judicial system. The Constitution is for protecting us and defining the powers of the government, protecting us from the government. It doesn't protect us from each other. We have a justice system established by statute that provides for that, and that's where these kinds of laws belong, in statute, where we can change them easily as we need. It should be very hard to change the Constitution, or either the state or the federal, and we should only do it for very specific purposes. So I wouldn't have a problem in concept with putting some of these things into statute. Most of them already are. Keep in mind, our entire judicial system, when it comes to criminal justice, is all a matter of public record. We have open trials. You can't be excluded from going in and watching a trial. Parole hearings, those are public matters. Everything happens by notice and hearing. Whether it's sufficient notice and hearing, we can debate that. But the fact is that notice and hearing does apply to everybody. And I think that we need to maintain those protections. Otherwise, we're going to inadvertently subject ourselves to the will of, in federal cases, more unelected judges. And even in our own state where they are elected, sometimes the political winds force them to make decisions that are contrary to the system of justice and equity.
Another dynamic, Vito Barbieri, District 2, another dynamic that I think is important to recognize is what we saw here with the Medicaid expansion vote we had. The misinformation by the millions of dollars that comes into the state. They establish a meme, they establish a messaging that doesn't necessarily have to be true. And so we have to remember that the individual that is pushing this Marsy's law, which by the way, is already misnamed, because it's not a law, it's a constitutional amendment. So we start off with the premise that this whole meme is it's just a law. But it's not. And then once this gets to the people, the misinformation to drive the population to make a vote one way or the other depends on how much money you spend and how catchy a phrase you have for your messaging. If we're already protecting these victims, if we've already got a provision in the Constitution, if we already have a sufficient, maybe we need to tweak that law, but if we already have statutory protections in place, what's going on here? What's going on here? So be aware, if, as the good Senator Souza says, I'm going to have the same equal vote you are during this process, but I'm going to have more information than you do, and you're going to have misinformation, we don't know what is going to happen to that, but we can be sure that a billionaire is going to spend money making sure that he gets this done. He's going to do it his way with his messaging. Standing is a very, very dangerous area to give victims. Standing means you can come into court and you can press just about anything you want with respect to the relevance of that case. Standing is extremely strong. The courts will use standing to keep you in or keep you out. But to give victims standing is a very powerful tool that if it becomes dangerous, we better be able to go in and tweak it and not have to try and figure out a new mean to send back to the populace to get a constitutional amendment to fix it. Remember, the Constitution is not easily changed, but if there's enough money, it'll happen. By the way, I want to recognize previous guy I got to blame for getting me involved here. Phil Hart's here, previous representative. Thank you.